So today I want us to shift our attention to undue influence as the fourth vitiating factors. Now, what is the meaning of undue influence? You see, undue influence happens when one party uses power, uses trust or authority over another person so that the weaker person cannot make an independent decision about a contract. According to the Black Dictionary of Law, undue influence is the improper use of power or the improper use of trust that removes a person's free will and replaces it with another person's wishes. An example is a religious leader persuading a follower to transfer property to them. Now, the effect of undue influence is that a contract made under undue influence is usually voidable at the option of the innocent party. But there is an important rule that I need you to always remember. You see, undue influence protects people whose judgment was dominated. It doesn't protect those who simply made bad decisions. And I think that is critical for us to remember. Now, when does undue influence exist? You see, undue influence exists in three main situations. The first situation is where you have a special relationship. And this is where we presume undue influence. And so here the law automatically assumes undue influence because one party has power over the other. And a good example is where you have a parent and child relationship, an advocate and client relationship, a doctor, patient, trustee, beneficiary, religious leader, and disciple. But the rule is that the strongest party must prove that the weaker party made an independent decision. For example, they obtained legal advice. We have the case of Alcott versus Skinner, an 1877 case, and it perfectly demonstrates undue influence. And the facts of this particular case were that Miss Alcott joined a religious sisterhood led by Mother Superior. Now, members had to obey strict rules, including poverty, including obedience, including surrendering property. And so this lady transferred her property to the sisterhood. And later she left and sought to recover her property, claiming undue influence. And so the issue in this particular case was whether the transfer of property was the product of undue influence. And the rule is that undue influence is presumed where there is a religious or spiritual authority kind of relationship. However, claims must be brought within reasonable time. And so the application of this particular case was that the Mother Superior exercised strong spiritual authority over Miss Alcott. She could not even consult outsiders without permission. This created a presumption of undue influence. However, she delayed to bring the claim. And so the conclusion of this particular case was that the court held that yes, there was undue influence, but the claim failed because it was time-barred. Further, if you look at the case of Ottoman Bank Company Limited versus Mawani, the facts of this particular case were that the defendant guaranteed a loan taken by his father's business. He worked in his father's company and depended on him financially. And so the business failed, and the bank sued the defendant to enforce the guarantee. And he claimed undue influence by his father. And the issue in this particular case was whether the guarantee was signed under the father's undue influence. And the rule is that where a relationship of dependence and control exists, undue influence may arise. Such contracts become voidable at the option of the weaker party. And so the application of this particular case was that the defendant depended financially on his father. He had no independent income, and this showed strong parental control, and therefore his consent was not independent. The conclusion of this particular case is that the court held that the guarantee was voidable due to undue influence, and so the defendant was not liable. Now, there are situations where you don't have a special relationship, and in situations where you don't have special relationship, actual undue influence must be proved. So that where parties do not share a special relationship, like the examples I've given, a parent and a child, a lawyer and a client, a doctor and a patient, undue influence is not presumed. And so here, the weaker party must prove a number of things. They must prove pressure existed. They must prove independence was lost. They must prove that decision was not voluntary. If you look at the case of William versus Barley, the facts of this particular case were that the defendant's son forged signatures and withdrew money from a bank. And so the bank threatened prosecution unless the father agreed to repay the money. So the father signed the agreement, and later he claimed undue influence. And the issue in this particular case was whether the bank exercised undue influence over the father. And the rule was that undue influence exists where pressure removes free and independent judgment, even without a special relationship. So that threats affecting close family members may actually amount to improper pressure. And so the application of this particular case was that the father signed the agreement to protect his son from prosecution. And so this pressure affected his freedom of choice. He did not act independently. The conclusion of this particular case was that the court held that the agreement was voidable due to undue influence. So the father was not liable. We also have situations where we have unconscionable bargains. So that an unconscionable bargain is a contract that is unfair, it is a contract that is oppressive, it is a contract that is one-sided. And usually it happens where one party is weak and the other party exploits that particular situation, so that terms heavily favor one party. Such contracts are usually voidable. And this doctrine was developed from equity courts. Now, if you look at the case of Lions Bank Limited versus Bundy, 1975, the facts of this particular case were that the defendant, an elderly farmer, guaranteed his son a business loan. Initially, he guaranteed £1,000. Later, he increased the guarantee to £6,000, and he finally increased it to £11,000 after pressure from the bank manager. Now, the bank manager knew the defendant, relied on him for financial advice. So the son's business collapsed, and the bank tried to enforce the guarantee. And the issue in this particular case was whether the guarantee was an unconscionable transaction caused by undue influence. And the rule is that where one party trusts another, or where one party depends on their advice, or where one party enters an unfair agreement, then the contract becomes voidable. And the application of this particular case was that the defendant relied on the bank manager's advice, and the manager knew this dependence. So the guarantee exposed the defendant's only property to risk. So the transaction was unfair. So the conclusion of this particular case was that the court held that the guarantee was voidable due to undue influence and unconscionability. So the bank could not enforce that particular guarantee. So that is all I have as far as undue influence is concerned. But when answering an undue influence question, it is always critical that you structure your answer like this: that undue influence exists where one party dominates another's will, number one. Secondly, where there is a relationship of trust. Thirdly, where independent judgment is lost. And number four, where the transaction benefits the stronger party. And we also have presumed undue influence, as I've pointed out, in situation where you have, parent, child, advocate, client, doctor, patient, trustee, beneficiary, religious leader, and disciple. Now, if it is presumed, then the stronger party must prove independent advice was obtained, and that, especially if, for example, it is a lawyer and a client, the lawyer has to prove that legal advice was actually given to the client. So that is all I have as far as undue influence is concerned. In our next lesson, we are going to talk about illegality. If it is your first time here, make sure you subscribe and you follow this channel for more legal lessons.